I would like to request all of you to please keep yourselves mute and अभी हम लोग within 5 minutes webinar शुरू करेंगे. Please keep yourself on mute. अभी चौधरी जी प्लीज अपना माइक म्यूट कर लीजिए.
अभी प्लीज अपना माइक म्यूट करो.
Welcome everyone. Thank you for joining us today for today's webinar on the topic Freedom of Speech with Harmonious Construction with Fundamental Duties. My name is Sakshi Mand and I welcome you on behalf of the ABVP family of Faculty of Law, University of Delhi. अखिल भारतीय विद्यार्थी परिषद एक ऑल इंडिया स्टूडेंट ऑर्गेनाइजेशन है जो कि एफिलिएटेड है राष्ट्रीय स्वयंसेवक संघ से और इसकी स्थापना 1949 में हुई थी. एबीवीपी दुनिया का सबसे बड़ा स्टूडेंट ऑर्गेनाइजेशन है जिसमें कि 3 मिलियन से भी ज्यादा मेंबर्स हैं. नाउ आई वुड लाइक टू इंट्रोड्यूस टू यू my co-host for today, Mr. Ushank Maheshwari, who will tell you a little bit about Constitution Day.
Thank you so much, Sakshi. Welcome, everyone. India made a tryst with destiny on 15 August 1947. The shape and the form of this destiny was entrenched in we the people on 26 November 1949. Today, we celebrate 71 years of this constitutional movement. As tempting as it may seem to start by quoting stalwarts of the Constituent Assembly, such as the likes of Dr. Bhimrao Ambedkar, Shyama Prasad Mukherjee, Vallabhbhai Patel, Rajendra Prasad, it must be resisted, not least because they have been quoted in plenty by many before. I would like, therefore, to begin with reminding ourselves with Dakshini, a young Dalit woman member from Kerala in the Constituent Assembly, said of the Constitution, a Constituent Assembly not only frames the Constitution but also gives the people a new framework of life. To frame a Constitution is an easy job because there are many models for us to imitate, but to renew a people on a new foundation require the synthetic vision of a planner. The independent, sovereign Republic of India plans a free society in India, Republic of tomorrow. The power will come from the people. The Constituent Assembly members knew they were shaping lives, livelihood, and the culture of every single citizen of India. And it's there for us to remember that this document not a legal framework to conduct the affairs of the nation, but indeed the framework of the life for all citizens of the nation. And now, without further delay, I would like to introduce to Siddharth Yadav ji. सिद्धार्थ यादव जी, आपका परिचय देना मैं अपना दायित्व समझता हूँ। सिद्धार्थ यादव जी ने अपनी ग्रेजुएशन एसआरसीसी दिल्ली यूनिवर्सिटी से करी है। उन्होंने अपने फैकल्टी ऑफ लॉ से ही करी है। और अब मैं सिद्धार्थ यादव जी से बोलना चाहता हूं कि वो आइए और कुछ शब्द हमारे सामने रखिए।
सभी को नमस्ते और आज के इस सुंदर सेशन में आप सभी का स्वागत है। मुझे स्वागत उद्बोधन के लिए रिक्वेस्ट करी गई थी। हमारे बीच में हमारे डिग्नेटरीज भी पहुंच गए हैं। सबसे पहले अपनी बात की शुरुआत करते हुए आज 26/11 भी है और इस देश में एक बहुत बड़े आतंकवादी हमले में हमारे देश के वीर सैनिकों ने अपनी शहादत आज के दिन में दी थी। तो उन सभी सैनिकों को अपने श्रद्धा सुमन अर्पित करते हुए मैं आज की बात की शुरुआत करता हूँ। ABVP लॉ फैकल्टी द्वारा ये एक सुंदर आयोजन आज यहाँ पर किया गया है संविधान दिवस के उपलक्ष्य में, और हम सब लॉ के स्टूडेंट्स, ग्रेजुएट्स, करंट स्टूडेंट्स, कुछ एस्पिरेंट्स जो लॉ फैकल्टी में पढ़ने आए हैं, आज वो जिस दिन हमारे संविधान को अडॉप्ट किया गया था, जिसको बाद में इनैक्ट किया गया, आज उस दिन को हम यहाँ पर मनाने के लिए सब लोग एकत्रित हुए हैं। बहुत से अच्छे वक्ता, अभी 2 अच्छे वक्ता हमारे फैकल्टी के, एक हमारे प्राध्यापक और एक देश के जाने माने वकील अधिवक्ता हमारे बीच में है, और उनका सानिध्य आज हमें इसमें प्राप्त होगा और बहुत सी जानकारियां अपने संविधान के बारे में हम सबको पता चलेंगी। पर उसको ध्यान में रखते हुए मुझे लगता है कि जो टॉपिक भी आज चुना गया है सभी ऑर्गेनाइजिंग कमेटी द्वारा, वो अपने आप में एक बड़ा सुंदर टॉपिक है। संविधान की जब तक इस देश में जब बात होती है तो ज्यादा अधिकारी, हमारे अधिकार क्या हैं उस संविधान में, हमारे राइट्स की बहुत बात होती है। पर आज के सेशन में जो ड्यूटीज हमारी हैं उस पे भी अगर हमारी लाइट जाएगी और हम लोग उस और भी अपना एक चिंतन करते हुए अगर मुझे लगता है कि आगे बढ़ेंगे तो इस सेशन की सार्थकता होगी। ABVP लॉ फैकल्टी, मुझे बड़ी खुशी होती है जानकर भी, बताते हुए भी, शेयर करते हुए भी कि लगातार बहुत अच्छे इवेंट्स समय समय पर ABVP लॉ फैकल्टी द्वारा आयोजित किए जाते हैं, जहाँ पे एक और कॉलेज में फैकल्टी में आने वाली समस्याओं को लेकर के एडमिनिस्ट्रेशन से एक और ABVP लड़ाई करती है। वहीं ये दूसरी ओर ये जो हमारा पक्ष है, सिद्धांतिक पक्ष, जहाँ पे स्टूडेंट्स को अपॉर्चुनिटीज देते हैं ऐसे सभी अवसरों में आकर के वो आए, कुछ सीखें, कुछ जाने, विचारों को जान सकें, सुन सकें, बोल सकें। मुझे लगता है कि ये वो जो आयोजन है, यही हमारे इस लॉ फैकल्टी की, इस यूनिट की और हमारे जो इंस्टीट्यूशन है, हमारा एजुकेशन सिस्टम है, इसकी खूबसूरती को बढ़ा रहे हैं। लॉ फैकल्टी द्वारा भी आगे आने वाले समय में भी ABVP के जो प्लान्स हैं वो अपने आप में बहुत व्यापक हैं। जिस प्रकार से इंटर्नशिप स्टूडेंट्स को प्रोवाइड कराने का प्लान है, सोशल इंटर्नशिप का प्रोजेक्ट उत्थान लॉन्च करने की बात जो अभी प्लानिंग चल रही है, उसको लेकर के एडमिशंस और क्रैश कोर्स में जिस प्रकार से स्टूडेंट्स की मदद की जाती है, अनेक इवेंट्स जिस हिसाब से प्लान्ड है, तो मैं ऐसे सभी जो ऑर्गेनाइजिंग कमेटी है, जो सभी लॉ फैकल्टी के कार्यकर्ता हैं, आज के इस कार्यक्रम है, मैं उन सबका को शुभकामनाएं देते हुए आप सभी का आज के इस इवेंट में स्वागत करता हूं। और आज के दिन में हम संविधान के सभी मूल्यों को दिल खोल करके मनाएं, उनको जानें, उन पे चलने का प्रयत्न करें, उन पे प्रतिज्ञा लें और प्रियम्बल से लेके संविधान के एक एक इतना हमारी कॉन्स्टिट्यूएंट असेंबली में इतने अनेकानेक डिस्कशंस के बाद, हजारों अमेंडमेंट्स के बाद एक इतना सुंदर कॉन्स्टिट्यूशन, एक डाइवर्स व्यापक कॉन्स्टिट्यूशन हमारे बीच में आया। इतने सब देशों से ओपिनियंस लेने के बाद, एक्सट्रैक्ट्स लेने के बाद एक इंडिया सेंट्रिक एक कॉन्स्टिट्यूशन हमारे बीच में है। आज उसके बारे में, उसके इंट्रिकेसीज को हम और जाने, उसके बारे में हमारे बीच में जो और वक्ता हैं, आज के हमारे मुख्य वक्ता जो हैं, वो हमारा ज्ञानवर्धन इस पे करें। इसी शुभकामना और शुभेच्छा के साथ मैं आप सभी का आज के सेशन में स्वागत करता हूं। बहुत बहुत धन्यवाद।
Thank you so much, Mr. Sidharth Yadav ji. Now, without further ado, we will be happy to introduce to you our speaker for today's webinar. Our first speaker and chief guest for today is Mr. Namit Saxena. He is an advocate on record at the Supreme Court of India. He completed his studies in law from Dr. Ram Manohar Lohia National Law University, Lucknow, and he has been practicing at the Supreme Court for over 7 years now. मुझे ये बताते हुए बहुत खुशी हो रही है कि नमित सक्सेना सर ने एडवोकेट्स ऑन रिकॉर्ड एग्जामिनेशन 2019 में सेकंड पोजीशन सिक्योर की है एंड उसके सम्मान में आज उन्हें कॉन्स्टिट्यूशन डे के अवसर पर सुप्रीम कोर्ट बार एसोसिएशन के द्वारा मेडल से पुरस्कृत किया जाएगा। मैं सर का धन्यवाद करना चाहूंगी कि उन्होंने हमारे वेबिनार के लिए अपने शेड्यूल से थोड़ा सा वक्त निकाला। थैंक यू सो मच सर फॉर कमिंग हियर टुडे। Now, sir, I would like to request you to kindly say a few words.
Thank you so much, Sakshi. Am I audible properly?
Yes, sir, you are audible.
All right. Hello, everyone. So the topic for today is freedom of speech and harmonious construction with fundamental duties. As Mr. Sidharth Yadav also pointed out, the topic is something which is very beautiful in nature. And when I received the topic, I had to actually sit down and ponder back as to, what can I actually speak on this particular topic. And then I decided that I should go in a chronological manner, starting from 1947 till date as to how, in a chronological manner, how things have happened throughout. So, see, whenever you study the Constitution is to be studied academically in two manners. One is that you study the Constitution, that is the written Constitution. And another is that you study the Constitution, which is something which is unwritten in nature. The written Constitution is the text of the Constitution, the bare act of the Constitution, which is written and it is readily available. The unwritten part of the Constitution is, which is something which is not in the text of the Constitution, which is not in the bare act of the Constitution, but is very well part of the Constitution as such. Now, the unwritten Constitution includes doctrinal Constitution. For example, we have the basic structure doctrine. We have, after doctrinal, there are, various supplements given by the judiciary through various pronouncements, through various interpretations. For example, the interpretation given to constitutional morality. Then we have the political climate. So, as a students of law, we must remember that the constitution of a country at the end of the day is a political document. So the political climate of the country affects the constitution, something which is unwritten in nature. Now, when we go to, the freedom of speech is something which is highly debated nowadays and something and is a concept which we must understand properly. So when the constitution was framed, so we obtained independence under a British statute book, that is the Indian Independence in 1947. We became independent on 15th of August 1947. We started a constituent assembly. Now, this assembly was not directly elected by the people. This assembly was, indirectly elected, and roughly around 28% of the then population of the country voted for the members of this constituent assembly. And it was based on proportional representation as well. The Constituent Assembly was divided into various committees. One of the committees was the drafting committee, which was headed by Mr. B.R. Ambedkar, who was also a distinguished lawyer. And there were various subcommittees. Now, one of the subcommittees in the drafting committee was the subcommittee on drafting of fundamental rights. Now, fundamental rights, as we know now today, is in part 3 of the Constitution. Now, Article 19(1)(a), something which came in the Constitution and has remained unchanged thereafter, guarantees a freedom of speech and expression. So it is not limited to freedom of speech alone. You can not only speak, but you have freedom to express yourself in any manner permissible under the Constitution. But no right, as we know, is absolute in nature. The right to freedom of speech and expression guaranteed under Article 19(1)(a) of the Constitution is limited by Article 19, Clause 2 of the Constitution, which now Article 19(1)(a) has remained unchanged, but Article 19, Clause 2 has seen at least three, or rather at least two major amendments in it. So, also, so see, when we talk about, before we delve into, the constitutional amendment, the first constitutional amendment which amended Article 19, Clause 2, we should know the political climate and, of, the time when 26th November was declared as the Constitution Day. See, we saw a major partition between India and West Pakistan and East Pakistan. So the atmosphere of the country then was, surcharged in a very communal manner. There were riots, there were multiple deaths across the country. There were various issues which the then ruling establishments faced. So when we, go into the study of freedom of speech and the First Amendment to it, we should remember the climate across it, because the country was going through a very hard period. We had recently, adopted the Constitution and achieved independence, and we had to face something which no one knew will come in such a manner. So on 26th November 1949, and now this is why it is celebrated as a Constitution Day as well, few articles of the Constitution came into picture, and there are after exactly 2 months, that's on 26th January 1950, the Constitution was fully adopted. So the Constituent Assembly, and now interestingly, the first Lok Sabha elections, that is the first elections in the independent India, were conducted only in 1952. Now in 1950, the Constitution was fully adopted and something major happened. Now, before we go into this, we should, also see the geographical situation in the country then. India was full of small states. Now, the Madras presidency, the then Madras presidency was made the Madras state in, south. And it included parts, and it included the current days Kerala, Andhra Pradesh, Karnataka, and Telangana, and Tamil Nadu. It was all combined as the Madras state when we became independent from Madras presidency, which was under the British rule. Similarly, Delhi was not a union territory in 1950. Delhi was called the Chief Commissioner's Province of Delhi. Uttar Pradesh was United Province. It was later amended. The name was later amended. So, I'll tell you why this is important. Now, there is a major case, rather there are two major cases which simultaneously happened, which led to the amendment in freedom of speech. There was a magazine called Crossroads, which was run by Mr. Romesh Thapar, who is the brother of historian Romila Thapar. Now, Crossroads had a major publication and a major audience in Madras state, particularly in the belt where we know the current day Kerala is. There was a rising of communist movement there. So it had a major, audience in that particular area, in that particular belt. Now, the then ruling establishment was under Mr. Jawaharlal Nehru, that was under Indian National Congress. The chief minister of the then Madras state was also from Indian National Congress. Another parallel to this, there was another magazine, and it still runs, that is called Organizer, the Organizer by RSS. That had a major audience in primarily the northern part of India, and a very high audience in Delhi. Now the Nehru government did, two major blows to these magazines. Crossroads was banned. Nehru government said that no, we can't let you publish anything which is against, the policies, or you are highly critical, so we'll ban you. They banned Crossroads. RSS magazine, that is the Organizer, was subjected to prior censorship, that whatever you want to publish, you have to get it first censored by the ruling establishment, and then only you'll be allowed to publish whatever you want to publish, in case you are allowed so. Now, Mr. Romesh Thapar, that is, the editor of Crossroads, and Mr. Brijbhushan, who was the editor of then the Organizer. They both, and this is interesting, I'll tell you why, because one was ultra left and one is right wing, as we know now today, liberal and conservative. They both approached the Supreme Court under Article 32, saying that this is something which is contrary to Article 19(1)(a), and this should thereafter, and both these notifications, they are therefore should go. The Supreme Court held in favor of them. The Supreme Court said, yes, these notifications are bad in law, and by a majority of 5:1, because at that particular time, the Supreme Court comprised of only 6 judges, and they used to sit en bloc. Like they used to sit all together. Unlike today, when we have benches of 2 and 3 and 5 judges, they all 6 judges used to sit together. So by a majority of 5:1, they said these notifications are bad in law because of the then Article 19 Clause 2, which limited Article 19(1)(a) then, does not allow the government to do so. So they were nullified and dusted. Now to overturn, now see, also again, you have to understand something which is, common in all civilizations. That is the tussle between two organs of the constitution, that is the executive or the legislature and the judiciary. So there is an eternal conflict amongst them for custodianship or the guardianship of the constitution. The legislature or the executive, they say that we are the direct will of, the people of the country because we are elected representatives. So we are the guardians of the constitution. The Supreme or the judiciary says that we have the powers of judicial review. Whatever you do is subject to the tests of the constitution and other statute books, and whatever you do or whatever exercise you carry on is subject to the powers of judicial review, which only we have. Therefore, we are the custodians of the constitution. So there is this eternal conflict in all civilizations on the guardianship of the custodianship of the constitution. Now, and this is where it kicked in India, because this was the first case where, apart from the land reforms judgments by, which there were multiple land reforms, which were brought forward by Mr. Nehru, and they were also nullified by various high courts and the Supreme Court. So, Mr. Nehru decided that, that, okay, you have given an interpretation, something which will come in my way throughout. So I'll amend the constitution, so that the Article 19 Clause 2, as we know, will be amended. So the first constitutional amendment came in 1951. And this was done by the very same Constituent Assembly which framed the constitution, because the first Lok Sabha elections were conducted only in 1952. Now the Article 19 Clause 2 pre-amendment, the first amendment, included, that state can make laws on which will restrict Article 19(1)(a), that is freedom of speech and expression. That will be libel, slander, defamation, contempt of court, any matter which offends against decency or morality, any matter which undermines security or tends to overthrow the state. This is the pre-amendment 19 Clause 2. Now this was amended by Mr. Nehru, and the expression reasonable restrictions was added. Early reasonable restrictions was not there. So the restrictions which have to be there on the right, which is fundamentally guaranteed by the Constitution, of speech and expression, cannot simply be restricted, but these restrictions have to be reasonable in nature. This was amended. One. Second, the expressions security of state, public order, decency, morality, friendly relations with foreign states, incitement to an offense, contempt of court, and defamation. These were added. So the first time, immediately after the constitution came into being, it was amended due to 2 judgments passed by the Supreme Court, wherein, the prior censorship and banning of 2 magazines, and those were 2, diametrically opposite ideological magazines, was shrugged off. So now a necessary, and this is important, I'll tell you why, because this triggered a chain reaction of, a constitutional tension between, in India, a constitutional tension between judiciary and the legislature. Now this went on for a while. In 1962, we had to face a war with China. After 1962, Article 19, Clause 2 was again amended in 1963 by the 16th Constitutional Amendment, and the expression sovereignty and integrity was added in Article 19, Clause 2. So the Article 19, 1A remained unchanged, and Article 19, Clause 2, as we know today, includes that, that state can impose reasonable restriction on 19(1)(a) for sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation, or incitement of an offense. Now, this is a right which is fundamental in nature. Now, in jurisprudence, we study an interesting concept that was given by Hofeld, that is called Hofeldian analysis. Hofeldian analysis says that every right has a correlative duty. If there is a right without any correlative duty, it gets converted into a privilege. It is no more a right, it is a privilege thereafter, which stands on a higher footing. Now, which right? Now, right can be a legal right, simple, a legal right guaranteed by a statute book. Right can be a constitutional right, for example, now as right to property, which is not fundamental in nature, but it remains a constitutional right. Or the right can be fundamental in nature, that can be a fundamental right. Now, can there be a correlative fundamental duty to a legal right? Or can there be a fundamental duty correlative to a constitutional right? Or there should only be a fundamental duty correlated to a fundamental right, is the question. Now, see, the expression fundamental is not a barren word. It has to be assigned some meaning. That is why it is, written in the Constitution. The expression fundamental, generates a significance, saying that something which is fundamental in nature, something which is basic to your existence, something without which, the state will, deprive you of, a right which is essential to you. So the fundamental duty which is correlative to this has to be of a similar nature. Now, when the Constitution came into being in 1950, there was no chapter on fundamental duties. Although this was discussed in the Constituent Assembly, but in their own wisdom, the founding fathers and mothers, they decided not to incorporate fundamental duties. Later on, another, after the war with the 1971 war with Pakistan, there were multiple factors, the political climate was also different. So a need arose that there should be a dedicated chapter on fundamental duties in the Constitution itself. Something which should not come by a notification, or something which should not come through a statute book, but it should be in the Constitution itself. The Constitution, is the highest, the top of, it sits on the top of the pyramid. Everything flows from the Constitution. Anything against the Constitution is ultra vires and will be shrugged off by the constitutional courts. So there was a Swan-Singh committee which was framed. Now, interestingly, in 1975, there was a national emergency which was imposed upon the country. And it is during this emergency period, a constitutional amendment was passed and the Constitution was amended by the 42nd Constitutional Amendment, which is also known as the mini Constitution, because it largely amended the Constitution to an extent which suited the then ruling establishment run by Mrs. Indira Gandhi. So one of the facets of this 42nd Constitutional Amendment was that it inserted Article 51 capital A in the Constitution, and which came into Chapter 4A, which said that we'll have a set of 10 fundamental duties. Another 11th fundamental duty was added in 2002. So for the first time, fundamental duties were inserted in the Constitution in 1976 after the Swan-Singh Committee's report. Now, the fundamental duties as we know today are 11, and at least 3 of them are in consonance or should be read in harmonious construction with the right to freedom of speech. I don't read it alone as freedom of speech. I always read it as freedom of speech and expression. But the topic says only freedom of speech. So if you'll say Article 51A, Clause A, so it says that it shall be the duty of every citizen of India to abide by the Constitution. Now, this is very important. The first duty is that you have to abide by the Constitution, and this is the duty which is fundamental in nature because this is correlated to your fundamental right. So, now the Constitution alone, no, that is why I said the Constitution is the written Constitution and the unwritten Constitution. Something which is not written in the text of the Constitution also has to be abided by. That is why we have a duty to abide by the basic structure doctrine, which is something which is not part of the Constitution as such in the written manner. But in the unwritten Constitution, it is very well part of it. Now, Article 51A, Clause C says that it shall be the duty of every citizen of India to uphold and protect the sovereignty, unity, and integrity of India. Now, the same expression, sovereignty and integrity, that is why we discussed the 16th Amendment in 1963 after the China War. The expression sovereignty and integrity was added in Article 19, Clause 2 of the Constitution. So, Article 19(1)(a), which guarantees a freedom, is restricted by Article 19, Clause 2. And Article 51A, Clause C guarantees a fundamental duty that it is, and it uses the expression shall. It shall be the duty of every citizen of India to uphold and protect the sovereignty, integrity, and unity of country. So there is a direct correlation between the reasonable restriction put on Article 19(1)(a) by Article 19, Clause 2 in sovereignty and integrity, and a correlative duty given in Article 19, in Article 51, Clause A, Clause C, 51A, Clause C, saying that you have to, that it is your duty to uphold and protect the sovereignty, unity, and integrity of India. So there is a direct, so that is why the expression in the topic, harmonious construction, kicks in, because there is a correlative duty direct to Article 19, Clause 2. Similarly, when you go forward in Article 51, Clause A, you see that you have to, in Clause 51A, Clause E, that you have to promote harmony and spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, and regional sectional diversities. So when you read the reasonable restriction of public order, decency, and morality, more particularly public order will remain when there is a diverse culture and there is harmony and a spirit of common brotherhood amongst the citizens. So it is the duty of every citizen. And these duties, also interestingly, these duties are irrespective of your faith, irrespective of your belief, irrespective of anything. Because these duties are not qualified by anything. These duties do not say that only, a particular class of citizens will follow them. All citizens, irrespective of everything, have a duty to do so. Now, there is a question which pops up in mind. And I'll tell you why these duties are necessary. These duties balance civic freedoms, because in a civil society, you have to given certain freedoms. So it balances civic freedoms with civic obligations. Now, you have a civic freedom of Article 19(1)(a), which is not absolute, restricted by 19, Clause 2. And you have a civic obligation, which is Article 51A in its 11 clauses, and more particularly 3 of them. And these fundamental duties, these are not merely, texts or words which are not to be followed. These are constitutional obligations, and these are constitutional expectations for every citizen to conform with. Now, as we go further, a very interesting question pops up. What if I don't follow my fundamental duty? What if I do something which is contrary to my duty written in the Constitution? Can I be punished? Is there a sanction? Because, that is why every law is defined. Law is something which is to be backed by a sanction. Is there a sanction? Are these duties enforceable in a court of law? The answer would be no. these are not enforceable directly, but there is an exception. There is an exception which also comes in form of another question, which I ask myself, I want you to ask yourself. Can these fundamental duties be converted on a case-to-case basis into fundamental rights? And then, because fundamental rights are definitely backed by sanction, because they are in form of negative and positive covenants. Something the state should do, the state cannot do, the state ought to do something. In these natures, it is written. So can fundamental duties be converted into fundamental rights and then be backed by a sanction? The answer to this would be yes. It has been done in past. The best example to this would be the Ram Leela Maidan case of Baba Ramdev, where there was a fundamental duty which he was conducting. The court said, okay, yes, but this is, backed by a fundamental right, that is the right to sleep under Article 21. Something which sounds funny, but it actually is not. So that, these rights are fundamental. Article 21, therefore, life and personal liberty has included, in its gambit a lot of things. So the answer to this is yes. Fundamental duties are not enforceable per se, but if they are converted or they are, backed by a fundamental right, they can very well be enforced. You can sue the state for not conforming with them. So freedom of speech in, in conformity with certain fundamental duties is in harmony with them. So when you read Article 19(1)(a), you read Article 19 Clause 2, you should also read Article 51(a), because where there is a right, there is a correlative duty, fundamental right, fundamental duty. So this is how, fundamental duties are to be checked and, be in conformity with the freedom of speech. Now, I'm sure you'll have multiple questions. So I'd love to answer if any of you have any questions, you can, shoot up to me. I'll love to answer them. Sakshi, you can, ask them to, shoot questions if they want to do.
Sure, sir. If you have any questions, you can type it in the chat box or you can directly ask sir. It will be better if you type it in the chat box and I will narrate that to sir. Does anyone have any question? Yes, you
All
can
right,
either type it. Okay. Yes, sir.
so let them, so you can all type in the chat box. In the meanwhile, let us also discuss something which is interesting and in the, current day scenario that is also relevant. So see, freedom of speech is regulated in a manner that you can't shout fire in a crowded room or in a closed cinema hall. Freedom of speech is something which is heavily debated nowadays. So, when you talk about freedom of speech and expression, there are multiple facets of it. There are multiple facets of it in the sense that, the expressions through which it is made, subject to the expressions used in Article 19 Clause 2. For example, public order, decency, morality, incitement of an offense. All these are very broad terms. Public order, and that is where, it makes them judge-centric instead of principled in nature. Public order to one particular judge or one particular individual can mean something else. Public order to someone else may mean something else. That is where the problem kicks in. Decency, morality, incitement, these are all very broad terms which make everything judge-centric or individual-centric. And that is why there is a big difference of opinion in freedom of speech. Now, recently, we have, we all have, on social media, a stand-up comedian posted something against the constitution. something against the Supreme Court and the CGI, and he posted certain images as well. Now as you see it, he claims that this is my freedom of speech and expression. I have a right to do so. I'm doing so. That's something which is not absolute, of course. But under which clause does it fall? So, does it disturb public order? Does it disturb morality, decency, security, integrity of India? What clause does it fall? So 19 clause 2 also includes contempt of court. So the state has made a Contempt of Courts Act 1971, and the Supreme Court has procedure to conduct the proceedings of contempt of the Supreme Court rules, that is of 1975. So there are multiple facets to it. The claim of freedom of speech is something which is not absolute in nature. But the reasonable restrictions put to it have to be understood in a principled manner. There are judgments, plethora of judgments, there are series of judgments which say that okay, this is something which will be a reasonable restriction. This is something which will not be a reasonable restriction. So it is to be understood in a holistic manner. Sakshi, you can ask questions. I guess there are 2-3 questions put up by
Sure, sir.
friends.
First, we will be taking up the question of Mr. Vishal Ashok Mishra. He is asking, Sir, why isn't duties included in Part 3 and made automatically enforceable as rights without duties?
See, the chapter on fundamental duties itself came late. It came in 1976. Part 3 came in 1950 of the Constitution. Now, there is a reason why fundamental duties are not made enforceable. See how constitutional rights, more particularly how fundamental rights are structured. Fundamental rights are structured with, as I said, positive and negative covenants. Fundamental rights anyway throughout, and we have a very descriptive constitution. Fundamental rights are structured or crafted in a manner that there will be a negative covenant in few fundamental rights. Few fundamental rights will use the expression citizens, few will read the expression persons, few would be in form of positive covenants. Now, the same principles of drafting of fundamental rights cannot be applied to drafting of fundamental duties. Because in fundamental duties, there will never be a negative covenant as such, because these are duties of citizens, not of the state. The duties of state come in your fundamental rights as citizens as positive and negative covenants. So the drafting of fundamental rights and fundamental duties are separate. So they can't be clubbed together directly in one particular chapter and make them enforceable as such. They are separate in their very existence. If you combine them, then they adopt roles of each other, and then you won't be able to distinguish between what is a right, what is a duty. So they have to be separated but connected. All right, Sakshi, next.
So the next question is from Mr. Krishna Kumar. He says, does freedom of speech include criticizing the judgment of court?
Yes, freedom of speech includes fair criticism of a judgment. But again, this is something also which is not absolute in nature. So see, a judgment is passed by a court. You can very well fairly criticize it. You can very well say that wrong facts were used or wrong law was applied, or this has not been decided in conformity with the precedents, and this is bad in law and this deserves to be declared as par inquirium. But see, in certain cases, for example, a lot of things in law are discretionary in nature, where a particular judge in his or her experience or his or her wisdom uses a discretion in a particular manner. For example, bail, grant of bail. Now, although we know bail is the rule, jail is an exception, and but at the end of the day, bail remains a discretion. So a particular judge applied his or her discretion in a manner and decided something, whatever he or she deemed correct in law and facts. You can very well criticize that, okay, this was not done in conformity with settled principles, But you cannot, take your challenge to the judge or cast aspersions upon the judge for using his or her discretion in his constitutional capacity. So this is also something which is not absolute in nature. You can very well criticize, and in case you feel so, your criticism may also be wrong. You must also remember this. Your criticism should be fair, but your criticism may be wrong. You may not know, certain facts, or your criticism you may apply, wrong law on it. But you can very well criticize it fairly. But casting aspersions upon the judge, something which has become very common nowadays, is something which deserves, which is not guaranteed under the Constitution. Sakshi.
Yeah. So the next question is from Mr. Himanshu Jaiswal. He asks, can you please give some of the examples where fundamental duties have been the basis for legislative and executive actions?
Multiple, many of them. For example, you know, and not only fundamental duties, but they came through judgments as well. For example, the entire environmental jurisprudence as we know today, that is, by the MC Mehta cases, it came in form of fundamental duties. He went to the court and said, how do I follow my fundamental duty? There is no law. There is absence of proper directions by the courts, by, executive. How do I follow my fundamental duty? Guide me. So the Supreme Court, there are judgments of 1985, cases of 1985 by MC Mehta, which are still running. But, multiple judgments, MC Mehta, then their right to education. If you'll see the 2002 amendment by which the 11th fundamental duty was inserted, that is, from the age of 6 to 14, that is the 86th amendment, that is also a correlative fundamental right in Article 21A, capital A. So there are multiple laws which have been done so.
Okay. So, sir, the next question is from Mr. Shubham Kumar. He says, is it usually said that the sense of
Sorry.
duty,
Is it?
it is usually said that the sense of duty must come from within, but there are certain duties which are inevitable. So, shall we go ahead with imposing certain duties?
See, the question of imposition of duties does not arise. The Constitution does not impose. There is a very famous argument in law which says that the Constitution, because, the preamble reads, we the people of India give ourselves the Constitution. So there's a very famous, argument against the Constitution that we did not adopt. So that is why I said the Constituent Assembly was not even roughly 28% of the, it did not even represent more than 28% of the then population of the country. So they said, we did not adopt this Constitution. This has been imposed upon us. But this argument was shrugged off, saying that, under the 1947 Act, India Independence Act, Section 8, Clause 1, this was, to be done, and which has been done in, their wisdom, and something which has protected you throughout. And under this Constitution itself, this territory is named India, that is Bharat, shall be a union of states under Article 1. So there is no question of imposition of fundamental duties. Also, you should remember that these fundamental duties are not exhaustive in nature. You can never say that, okay, I'll follow only these 11 fundamental duties to the best of my comprehension, and beyond this, I will not do anything. So the list of fundamental duties, it does not say that I can't spit in public, I'll spit in public. But the act or omission which you do can very well be under any law under which the state may have a right to impose certain restrictions on you. And if you'll see these 11 duties, they're very broad. For example, it says to safeguard public property and to abjure violence. Now, this is something very broad in nature. So one, you shouldn't look at fundamental duties as impositions. Second, the duties which you feel by your very nature should be done. You shouldn't wait for, them to be included in fundamental duties. These are duties which are fundamental in nature. This is a set which is given to you. Okay, these are fundamental in nature. So don't confuse between the two terms. Yes.
So the next question is from Mr. Dhairya Malhotra. He says, sir, don't you think that by enforcing fundamental duties and making them compulsory to follow will make the citizens more disciplined and patriotic?
No, I don't think so. The day these duties are imposed, the very essence of these being duties will go away. These duties, you know, uh, these are meant to be duties. These are not meant to be impositions. So these are duties which encourage you to strive towards something better, to encourage every citizen that okay, I have to follow this, to inculcate a feeling and to cultivate a sense of patriotism, a sense of to abide by the constitution or constitutional values. That is why I said these are not mere words. These are constitutional obligations and constitutional expectations. So the day you impose them, the essence of them being a duty goes away. You don't impose fundamental duties on citizens. Yes.
Excuse me, sir. Sir, I'm Dhairya Malhotra.
Yeah.
Yes, sir. Sir, sir, I've also given one example about that. Some people feel ashamed to say Vande Mataram and Bharat Mata Ki Jai and even disrespect national flag, as we can commonly see in Jammu Kashmir side. So, sir, don't you think that these people should also be prosecuted by
Yes. So
enforcing
see,
fundamental duties?
yes, if you'll see Article 51, capital A clause, 51A clause A, I guess, that is, that you have to, honor national flag and national emblems. Now you have a 1971 Act, which is, something called Prevention of Honor of National Emblems, or, and Section 3 of that particular 1971 Act, it lays down, that if you don't do so, you'll be prosecuted and you'll be booked. So there is a separate law for that, which came prior to the fundamental duty because it came in 1971. See, the problem which we face is that, you know, that there are multiple laws which are present. The implementation part is not effective because because the police as such is under the state list in the constitution. So, the ruling establishments, the danda is in the hands of the states. So, there are multiple issues involved. The ruling establishments change, ruling establishments who are not strict enough come, there are coalition governments. There are multiple, Nitesh has said prevention of insult of national honor at 1971. So that is there. So they shouldn't be enforced through fundamental duties. There is a separate law for it. Similarly, we have multiple laws in presence. Yes, Sakshi.
First of all, I would like to request all the participants that you guys please don't unmute yourself as we have time restrictions. So I will be taking up the questions which we think are fit, and that is just a request. Please don't unmute yourself. And the last question is by Mr. Amitanj Yadav. He says, don't you think, sir, Constitution gives us so many rights, but now it's time to make some duties enforceable by law to make our citizens more disciplined, socially and morally, because freedom also has some limits.
See, I differ slightly with you, Amtaj. See, that is why, at the risk of, being criticized for repetition, you don't impose fundamental duties. You don't enforce fundamental duties. The day you start imposing or enforcing fundamental duties, the very essence will go. This is something which is in the form and in the nature to, cultivate a feeling of, striving towards a better future and to do something which is better. The indirect route of enforcing fundamental duties can be by making or, improving or laws which are already in place to an extent that they are backed by sanctions. And most of them are already backed by sanctions. But duties are not something, it's fundamental duties are something which can be thrusted upon people that, okay, we will make them enforceable if you don't do so. Because if the day the state starts prosecuting, citizens of a particular land for not, fulfilling, in the state's wisdom, fundamental duties to their fullest extent, And these are very broad terms. For example, I said to safeguard public property and to abjure violence is something which is very, very, very broad. So now, for example, this is also backed by sanction. There is a 1984 law which says that you can't, like in all riots, you see ki bus jaladi and all these things. They are all banned. There is prosecution which is to be done for it. There is a Supreme Court judgment as well, something which the Yogi Adityanath government in Uttar Pradesh did in anti-CAA riots. So, but you shouldn't enforce fundamental duties directly. In an indirect manner, it can very well be done, and it has been done throughout. Yes, Akshay.
Yes, sir. So the last question is by Mr. Vinayan Singh. Sir, this is Contempt Act in India, along with the constitutional provisions, enough to demarcate the thin line between contempt and fair criticism?
I think yes. See, if you read the Contempt of Courts Act, contempt is of two types, civil and criminal. Civil contempt is willful disobedience. For example, there is, a direction of a court, you disobey it. That disobedience is also qualified with by, willfully doing it. Criminal contempt is scandalizing the court or, hampering with the administration of justice. Now, you should also see, that the Contempt of Courts Act is not a tool of operation in the hands of court. Contempt of court is to be used sparingly, one, and it is to be used in a manner, because see, always remember, you know, there's a very famous quote by Shakespeare. Oh, it is lovely to have, the powers of a giant, but it is, better to, not use like one. So, the power of contempt lies in the restraint of using it. So, contempt of court and fair criticism. See, fair criticism is anyhow a defense in contempt, but it has to be used in a manner that, for example, the Kunal Kamra episode. Now, the Supreme Court should not, I don't think Supreme Court should punish him. The Supreme Court should not, say that that a stand-up comic can, deter our position. Because one, it will give, nothing good will happen to the Supreme Court by punishing him. Second, Mr. Kunal Kamra will get unnecessary limelight. Third, it will encourage people to come into limelight by saying something against the Supreme Court. The Supreme Court should give it away, saying and giving an impression that we don't even care. This will deter. The day Supreme Court says that we don't even care what a stand-up comic says on a social media platform, it actually does not affect us at all. The day the Supreme Court says this, all of these people will stop saying anything against the court because they'll be deterred. They'll say, what is the point of saying against the court? Because they don't care. So contempt of court is something which is to be used, very sharply and not for everything. For example, when Mr. Prashant Bhushan, as an advocate on record of the Supreme Court, tweeted something, that is something which is to be taken seriously because he's an advocate on record of the court, not a stand-up comic. He does not deserve this. He can't be encouraged, and others can't be encouraged by doing so. Yes, Akshay.
Yeah, so that was the last question, sir. Now I would like to hand over the mic to Ushank Maheshwari.
अरे
Thank you.
खराब कर दी यार ये लड़की.
Sorry, can you
I
please unmute yourself? Sorry,
Ashwini
can you
Soni,
please
please unmute yourself.
mute yourself, please? Yeah, Ushank, please continue.
I extend a really hearty thanks to you, Namit Saxena, sir. You spared time from your busiest schedule to grace the occasion. Today we had an opportunity to hear your thoughts, and this will surely encourage us in our future event. We have students who have joined the faculty this year. It is the best maiden session, I must say. Thank you again, sir.
Thank you so much, sir.
Thank you so much. A happy Constitution Day to all of you.
Happy
And stay
Constitution Day.
safe, stay inside. There is a pandemic which has, hit all of us. All the best. Thank you.
Thank you.
Thank
So
you.
now with yeah, please keep yourselves on mute. Okay, so now with a heavy heart, I am regretting to inform you all that our second speaker for the day, Mr. Pramod Tiwari sir, who is also from our faculty of law, will not be able to join us today because he is having some technical issues. The internet connection at his side is really slow, so he was not able to join. And we are really sorry to say that, because it would have been a privilege to have him here today. He's a great professor, and he was trying to connect, but due to the technical issues, he couldn't. So now I would like Ushank Maheshwari to please take over and call for the vote of thanks.
Thank you, Sakshi. Now I would request Mr. Saurabh Dwivedi, Vice President, Campus Law Center, to give the vote of thanks. Saurabh, sir.
Thank you, Shank. Am I audible? Hello.
You are audible.
Yes, sir. Yes, you are.
Thank you very much. Good afternoon, all. I deem it a great honor and privilege to propose the vote of thanks on this memorable occasion. Let me first of all start by giving glory to the Almighty God for making today's occasion a resounding success. First and foremost, I thank our special guest, Mr. Namit Saxena, sir, Advocate on Record, Supreme Court of India, who, despite his busy schedule, has found time to grace this occasion. And I also express my heartfelt thanks to Dr. Pramod Tiwari, Assistant Professor, Faculty of Law, Delhi University. Although sir is not among us, but I would like to extend my thanks for his valuable contribution. We are grateful to Sidharth Yadav ji for his words of encouragement. His able guidance has always encouraged us. I thank him for his kindness, his interest, his hospitality, and continued support to us. I also extend my thanks to various heads of the ABVP Faculty of Law for their valuable contribution. I thank all the distinguished invitees present here accepting our invitation, and I thank the members of the ABVP CLC unit for their valuable support. And at last, I would like to extend my thanks to the host, Sakshi and Ushan, for their valuable contribution towards this program. Last but not the least, I would like to thank everyone who is present here in this on this auspicious day. Finally, I leave you this with the inspiring quote by Martin Luther King: "An individual has not started living until he rises above the confines of his individualistic concern to the broader concern of all humanity." Once again, I thank you all for your attention. Thank you. Over to you, Ushank.
Now, thank you, everyone. It was a pleasure being with you today. We appreciate your presence. Have a nice day and a happy Constitution Day. Thank you, everyone.
Thank you, Saurabh, sir.
Thank you so much, everyone, for being here. You may leave the meeting now.